topic definitely has engaged us in the last couple of months, weeks, not just because of COVID-19, but also that we have learned based on COVID-19 how we can work and that it is possible to work from home without any big issues. At least we think there are not any big issues. So to go a bit back in what happened and why we have chosen as well to have that topic today, it's yes, during the last months, basically since COVID-19 arose and people had to work from home, we experienced that this is possible. And then some of us not just worked from home in the same country the employer was situated, but some as well maybe got stuck somewhere where they were traveling, as well as some maybe also kind of moved back, or at least partially went back to their families in case they had been abroad, because they did not want to be disconnected during that period. And the technical side has shown us that there's, for most of us, not really a big issue in working from home or from somewhere else, and that we do not need necessarily to be in the office. Based on that, that has becoming a kind of a hot topic for companies. And if I look now at our daily work, in the years before COVID-19, this had been sporadically an issue with some of our clients, but since COVID-19, it has been one of the challenges each of the companies do want to get a solution to, as well as they do want to see whether there is any possibility also for the future in keeping up the same kind of work pattern. As said, from the technical side, this was not as big as an issue as some of us may have thought. It was more an issue, or is more an issue, from the legal side, and we will look at that in a second. Before we start, a simple sample in this regard. Ms. Miller is employed by a Swiss finance institute in Zurich. During the COVID-19 period, Ms. Miller worked from home. Due to this, she asked her employer to beginning of this year whether she could also work out of the UK permanently, where her husband lives. She added, in case there are no permanent solutions, she would like to at least work for the next 6 months from the UK. Ms. Miller is a UK national. Her line manager responded that from a technical and business work point of view, she can work from the UK, so he has no problem with that. However, the line manager informs her that he first needs to clarify this with the HR. This is basically now as well that where we get involved, and that we are sometimes then kind of the bad guys, because we are then saying that this might not be as easily possible as everybody thinks. Now, we have seen in some of the companies that some use the term remote employment, some use the term virtual employment. So I don't know what you use in your company for this, but we've seen both terms. More often in the past couple of months, we saw the term to be used as remote employment. In the end, both means the same. The employer is working from their home, wherever home is, or from another place, but it's not the employer's usual place of business. So it is just outside of the employer's premises, or where usually the employee will work. And anywhere where that is called as remote employment or virtual employment. At least if that is done not just for a day, but for a longer term. Now, why that is a hot topic, or why we not just say, okay, from an legal point of view, it is very difficult to get it maybe correctly set up, and compliance is there an issue. We rather see also then the benefits of it, and there are benefits for employees, like there is a better or a more flexible lifestyle they can have. Um, they in some of the surveys which you can find to that topic, it is indicated that employees can have a better health and wellness understanding. Work-life principle is better in place, and apparently employees have more passion for their job. We have taken that out, these kind of benefits, from several surveys which we have found, which had been done in the last couple of months. Now, there are apparently also benefits for the employers, which is basically a higher productivity, because also people do not have to travel to work, so they can spend their time more productive, even if they are not really working, or some of them are not really working much longer. There are some cost savings, but we will also see in a second that there are some of the cost, or some of the factors might cost a little bit more. But in principle, cost savings like rent, or things like canteen facilities or things like that definitely will go down in costs. And apparently employees are more engaged in their job and everything. So these are the benefits then for the employer. There are some of the misconceptions we also wanted to list, to give to have in the end the full picture. Like in the beginning, there were always the issue that it was said that there is a trouble in communicating, which is not true. That employees will work 24/7 and are online all the time, which is not is basically not really the case. I mean, there are still people who are 24/7 online, but in principle, now with that kind of working pattern now, which we have seen in the last about 10 to 12 months, we are getting used to it, and it's also getting in a kind of routine. And the misconception that people think that employees do not really work is also not true. It is also correct that employers have seen or found kind of solution how to see that their employees are working, and to see that there is a kind of checking on it. But if we look at the general aspects to it, we basically can say it is would be a perfect situation if one of the employees would like to rather work from home, or maybe just work 80% from home and comes every week 1 day in the office. Would be a perfect solution, which might help then everybody. However, there are a couple of legal aspects as well. Now, if we look at just that people work currently from home and not from the office, if it's in the same country, then we do not really have an issue. However, if it's in a different country, there are a couple of factors we really have to look at. On the employee side, the employee might get taxed in the other country. If we think about our sample of Miss Miller, who actually went back to the UK to her husband and worked out of the UK. Definitely what needs to be checked also on her side is whether she is subject to UK income tax or not. If she is a UK national, and if we think that, or we assume that she has a B permit only for Switzerland, then what happens from a tax point of view, she is, her employer most likely will still deduct Swiss tax at source. However, maybe she is not really subject to taxation in Switzerland, but actually in the UK. Employees as well have to look at insurance coverage. Now, if someone who has been resident in Switzerland is now or wants now to work from abroad, then definitely the health insurance is something the individual has to look after and to see whether in the country they do want to work out from, that the health insurance they have, the coverage is sufficient. As well as the immigration part, which is also something the employee himself has to look at because it's a personal matter as well. Now, if we look back at the sample from Ms. Miller, then we can say she is a UK national, so no problem at all in regard to immigration. However, if we have a different person who might not have the nationality or the citizenship of the country, then there is a big issue, because in some countries we might have the matter that there is a need of a sponsor for the work permit to get. In some we might have not that situation, and we are a bit flexible. If we see where is maybe there a potential to have such kind of situation from an immigration perspective now, if we look at the EU and the regulation in the EU, then we could basically say that we could offer people who are EU nationals and working in any other EU member state without any problems, because based of the EU citizenship, they are basically allowed to work wherever they want. If we go in other countries, then we do have a matter of when the employee has not the citizenship of the country they want to work out of, whether there is any immigration problem. Now, even if we say from an EU regulation there is no problem at all that someone, maybe a French national, can work in Spain, or the Spanish national can work out of Italy, that is true. However, what we also have to look at is that they are working for a Swiss employer. So what we have to do in addition is to check whether there needs to be that posted worker notification, whether that is an issue and whether we need to do something in this regard, because they are working for an employer which is not situated in the country they are working. So still we need to verify whether the possibility that an EU national, for example, could work in another EU member state. For the employer, it is as well the immigration factor might be the tricky one, as just outlined. In case we are going outside of the EU and there is then the requirement of having a sponsor in the country, then that might be already the point where we have to say, okay, it's not possible we won't get the work permit for that individual, then yeah, sorry, but it's not possible, and we have to go back to the employee and say, this will not work. The other factor, which is then also the employer has to look at, is the factor about payroll, social security, income tax, which is also a bit combined. Basically, from a social security point of view, if Miss Miller now would work out of the UK, then she will be subject to the UK social security and not any longer to the Swiss social security, because she's not working physically, not working from Switzerland. And the point, or the country in which an individual is subject to social security is always the country in which the employee performs the work. Now, there are a couple of exceptions from this, and one is in regard if we do have an assignment, then during that assignment period, someone can be exempted from the social security in the country they are really working, and the social security liability would remain in the country they are employed with. In our example from Ms. Miller, this would be if she would be assigned to the UK, then we do have a treaty between Switzerland and the UK, and that bilateral treaty will be has to be looked at, and there's the possibility to get her exempted from the social security in the UK, and then remain her, or keeping her under the Swiss social security system. The thing is just that she is not assigned, she is working locally in the UK, and therefore that that article about the assignment is not relevant. So what we have to do is we have to look at national law, which are the requirement, and then if you think about that, you have an employee working for you if we take the example in the UK, you may have now the situation that you have to take out UK insurances, whichever are in the end then required, as well as you have to get the individual registered with the UK social security system. And on the other hand, you would have to terminate or end the social security liability in Switzerland. So basically, this will then take or be a bit of work, as well as there will be other costs involved. If you are a Swiss company, then most likely you will say, okay, we may can read the one or the other thing about the UK social security system, but we are not the experts, so we do need to recruit somebody who is taking care of the social security aspects, as well as then basically the shadow payrolling in the UK. So there you would have a bit of extra costs for someone running the payroll abroad. However, you would save a part in Switzerland. Income tax, there as well, you would have to check whether income taxation is a matter you as an employer has to look at, meaning you will have to deduct the income tax on a monthly basis, or on when you run the payroll, or whether the situation is that the income taxation is something the employee has to take care on its own, because basically the employee is working out of a country where you as an employer have no premises. So this has to be looked at and verified and clarified in the end. Depending now as well on how long the employee is working out of that country, and where the employee has worked before, there might be even labor law implications you have to look at. We have also a couple of clients who now think in the future they basically hire employees. They are already outside of Switzerland, outside from their work premises, and they say most likely 80% of their work they can basically do from wherever they currently are. So instead of having the huge cost of relocating them to Switzerland, and then maybe the family or the kids do not really like it, difference of language matters, different school system, maybe the spouse is already is working, and therefore she would have to, or he would have to, stop working and trying to find a new job in a different country. So instead of all these costs and that hassle, we keep the employee wherever they or he is, and then just for maybe a week in a month, or maybe even every second month, only a week, we will fly in the employee. He has to be then in the office. We discuss everything, and then he can go back and working from home again. If we have these kind of circumstances, then definitely we have to look at the labor law implications in the country they are usually working. If we look at the situation of Karen Miller, then we may have labor law implications, meaning that UK law might be applicable, or in a portion might be applicable, or we can still say, because it's only temporary, the main workplace is still the UK, is still Switzerland. It's just on a temporary basis. Therefore, we don't have to do anything. And there might be also, we have to differentiate between the mandatory legal labor law provisions, as well as some of the others where where Switzerland can, or where the decision can be taken that the Swiss law might be applicable and not the UK one. But it has to be clarified for each of the circumstances. And if you think about the labor law from other countries, then you also know that the Swiss one is a bit more employer driven still, where other laws are considering more the employee as the major point and are more employee driven. Last but not least, you will have to look at the permanent establishment risk, meaning whether the employee now working not in your premises but outside of those premises in a different country, whether with him or her working in that country, there is a risk of permanent establishment. And the last part is there are a couple of special COVID-19 regulations which helps us at the moment to work outside of the usual country where we usually work, but still they are now going towards their end, and then we have to see how we can best do that in future. And if you now have the task in front of you to see or verify whether there is a possibility that you can offer your employees that we learned from a technical aspect, there's no problem at all. So if you want, you can work for a couple of months or a certain period outside of Switzerland and work from anywhere else, then yes, from a technical point, maybe, but from a legal point of view, you have to think about all these kind of consequences and points we just have discussed or seen, which are relevant in that matter. And you see there as well there are a couple of tricky issues where you have to look at, and maybe the best approach is to, in the end, if you really want to have that kind of offer, you define a couple of countries, and there you clarify everything and set up everything so that that is for the employee as well as for the employer a good way to work forward. This was a short overview about the different aspects. Now we do have received a question, and the question is posted workers registrations in the EU country. Can this be done for the employee if she works in the EU country for pure personal reasons? Yes, there is a possibility to do that. But you have to check that in each country, because not every country has the same way of looking at it. There is the possibility to do that. At least I know 3 or 4 countries in where you can do that, but I can't tell you whether that is now for all the countries a possibility. The A1 should not be applied for if the employee works in the EU country for personal reasons, right? The thing is, if in principle somebody is working for personal reasons in a different country, then it's not really an assignment. Now, for the A1, you can also put down, instead of assignment, that somebody works in various countries, like this for these business travelers who are working at different EU member states. And there you can also tick that to get an A1. Now, the thing is whether the A1 is in any case the right way, and whether or not the employee is actually subject to Social Security in the country he wants to work from. So before looking at the A1, you first need to clarify whether the Social Security in the country the individual is arising, is working from, is really a possibility or not. This is actually also the only question we have received. I hope I was able to answer that. Thank you very much for your patience and staying with us a bit longer. I'm very sorry for the inconvenience and for the problem, which in the end then was that we had to delay the event. Thank you very much for your attention, and I hope to see you soon in one of our next events. Thank you and have a very good day.